Good. Okay, great. Hi, everyone. Thanks for coming, those in person, and I know we have a lot of folks attending virtually. Um, I am Kelly Gastley, I'm the managing attorney here at VIP. I am filling in for my colleague Vijaya, who is here on Zoom today, but is a little under the weather. So I am pinch hitting for her a little bit. And coming in to help with this training along with Sierra Applegate, who I will allow to introduce herself.
Hi, everybody. I'm Sierra Applegate. I work for the City Solicitor's Office in the Real Estate and Economic Development Unit, and I serve as a volunteer attorney with Philadelphia VIP for several years now, doing estate planning work specifically.
So thank you. We're really grateful to have Sierra's time here and also to have the input and perspective of a volunteer attorney who's actually helped clients through estate planning documents before. So I think it will be really helpful for you all to hear from Sierra as to things she's encountered and how she's approached this before. So we'll talk a little bit about the mechanics, the logistics of the clinic at the very end, but for now we're going to kind of just jump into the substance instead of importance of estate planning and kind of walking through each of the documents. So Vijaya is going to be putting in the chat for those who are online. Some of the documents we're going to be referencing. I've handed out a few copies to folks who are here in person. We're going to send everyone things afterwards as well. So you have a link to like our complete training manual to look at later, and a few other documents you might want to reference. But to kick off, just thinking about why estate planning is important. I think we all kind of know. I think a lot of us kind of have some ideas of why it's important, right? A lot of us think about like, hey, we want to make sure like families aren't fighting, which is always nice if we can avoid that. But there's also a lot of other benefits for clients, especially our clients who are often living in poverty. It really does help to preserve that intergenerational wealth, meaning we can really make sure that wealth is transferred from one generation to the next by making sure the right estate planning documents are in place. And that we don't have issues like a lot of the tangle title issues that VIP also works on and that some of you may have worked on. We can prevent a lot of those from coming up if we have proper estate planning documents in place. And so it's really important when we think about that larger concept of trying to preserve that wealth from generation to generation. And also, of course, making sure that folks are having conversations with their loved ones about what their wishes are if they become incapacitated or they die. And making sure that we're kind of helping them think through the consequences of different routes, different decisions they might make, and what might be the best for them and their family. So we're going to talk about today a few of the most common estate planning documents, including the ones that we ask volunteers to do. For some of you, your clients may only want one or two of these documents. For others, they might want all of them. We've identified that for you if we've already matched you with your client, we've already identified what documents they've told us they wanted. So it's not a mystery. You should already kind of have that guidance and know going into the case what documents your client's looking for. But these are the financial power of attorney, healthcare power of attorney, which for us, our template incorporates the living will concept as well, and then a will as well to give away property. So these are the core documents that we focus on here at VIP. We want to make sure that folks are having discussions with their family members and that you all are having discussions with your clients about what decisions they want to make as you're preparing these documents. Counseling is a really important part of this process, which is why we're not just matching you with a client today and saying, hey, in the next hour and a half, produce your client's estate planning documents, and we're going to sign them and get them notarized, and they're going to leave with them today. At VIP, we really like to kind of take a little bit more time and make sure that our clients have the opportunity to talk through with you what they're thinking about, and you have an opportunity to play that counselor role that we don't always think of as attorneys, but to be the counselor and kind of talk to them a little bit about, are you sure that's what you want? Have you thought about X, Y, or Z, right? Are you sure you want to name 3 people as the executor of your will? Maybe not the best idea. And that's a really important role that you all will be able to play throughout this. So things to keep in mind, what I just touched on was, providing counseling to your client, but making sure that yes, you are providing the counseling, but at the end of the day, it is your client's decision. And it is their judgment as to what works best for them and for their family. And making sure that you're kind of keeping that in mind, that it may or may not be the decision you would make, but as long as you feel like the client has the right information and understands the consequences you're drawing out for them, that judgment and that decision they're making it should hopefully be the right one for them. Be aware of family members who might be involved. We try to make sure that when we are working with clients before we match them with a volunteer, if we are encountering a family member who seems to be very, very involved, maybe even a little aggressive with, hey, this is what my mom wants in her will. She wants to name me her agent so I can deal with her bank accounts. We try to kind of tackle that before we even ask you to get involved, to make sure that we don't have a situation we're worried about someone who's improperly influencing the clients or being a little bit too strong-willed. But be aware of that as well. If it's something that hasn't come up yet, when we've been working with them here at VIP, and then you start getting, it's only the client's never calling you back, it's always the client's son, that might be, a yellow flag or a red flag that maybe we pause and think about, do we feel comfortable that the client's really fully engaged in this process? So just one other thing I wanted to point out, Vijaya is going to put this in the chat as well, but we have a great estate planning questionnaire that we will send out to everyone afterwards. That's a really good template that you can use when you start to have your first conversation with your client about kind of walking through who their, key family members and other relationships are, what they might, trying to gather information for what they might want in these key estate planning documents. So in the training manual, it's on page 35. It's also a freestanding document on our website in our resource library that you can find, but that's a really helpful tool to start to have that first conversation with your client. Okay, so from here, I'm gonna hand it over to Sierra to start with talking about our financial powers of attorney.
Sure. The financial powers of attorney document is a document where the principal gives the agent the authority to manage their financial affairs or healthcare decision making. It's a document wherein the person might be incapacitated, or the person might be unavailable, maybe immobile, maybe limited in some way, and so they need someone in place to make these decisions for them, manage their banking. Maybe they have online banking and they need assistance with that. Maybe they need assistance with selling their house. Maybe they need assistance with Medicaid or Medicare or different government benefits. This is a document that gives the agent the authority to do some of those things. So there's a general financial power of attorney, and then the limited financial power of attorney. I only have experience drafting the general financial power of attorney, which gives the agent the power to manage all aspects of a person's finances. So their real estate, bank accounts, any other income that they receive, paying bills. And then there's the limited financial power of attorney, which is tailored to grant specific powers to the agent. And that might be the agent only has the authority to sell my house or something in that capacity. You can go to the next slide.
Oh, and just so folks know too, all of you here in person, you have a template for each of the powers of attorney in the will. If you want to look at those, and folks online, Vijay is putting those in the chat. So if you want to pull up the actual documents to take a look at as we're talking through, you can.
Springing versus durable. Again, I only have experience with the durable financial powers of attorney, not the springing financial power of attorney. Durable it's effective once the document is, sorry, I'm not explaining it right. The durable financial power of attorney extends beyond the capacity of the person. So if the person becomes mentally incapacitated, the durable financial power of attorney still stands. Whereas in some cases, the person may have to go through the guardianship process in orphans court. The durable financial power of attorney avoids that process sometimes. And then there's the springing financial power of attorney, which goes into effect there's an event that happens and it goes into effect that way. And usually you need the physician to state that the person is incapacitated, which can be challenging, especially if it's something that's urgent. It's a document that's needed in place and it's urgent. Not recommended. Okay, so this won't be drafted by Philadelphia VIP, and many states no longer permit bringing financial power to attorneys.
They really just cause like unnecessary complications for our clients and, you know, might mean that there isn't actually an agent poised and ready to help in the situation when it's most needed.
I'm just thinking about a current situation right now where my cousin has a durable financial power of attorney, but the principal is declining and certain things need to happen. And if this was one that limited her ability to act and she needed to go through the orphans court process, it just would be very time consuming. So yeah, durable financial powers of attorney are the way to go. You go to the next slide. Oh no, that is the right slide. Sorry. So the agent is the fiduciary, and a fiduciary is someone who can be pulled into court. They can be required to provide an accounting of what they've been doing with the principal's funds. They are supposed to keep detailed records and receipts and a really robust accounting of what they've been doing on behalf of the principal. They can't commingle funds. They are supposed to do everything in the best interest of the principal. And then joint co-agents and successor agents, joint or co-agents have to act jointly, not independently, unless it's stated that they can work separately. I've had clients who wanted maybe both their children to be involved in the decision-making. So they might be listed as joint agents, but then I'll put in the document that this particular child has the final say. It's also important to name an alternate or successor. There are some agents where that might be like tricky because maybe they don't have a lot of family or maybe they don't have children, but I always advise them to think about the people that, in their lives that they trust, to have someone in place in the event that the person that you name predeceases you. You can move on to the next slide.
Do you want to talk about hot powers now or you want to wait?
Yeah, we could talk about the hot powers now.
Powers, I mean, this is like the most exciting, it's the sexiest name in an estate planning training you're gonna get, so tune in for this part.
The hot powers are actually on page 3 for the people who have the documents in front of them. These are powers that have to be specifically stated in the document. You have some clients, you'll go through them and they don't want them in here, so you just delete them. But I wanted to kind of talk about what each kind of means. I'll try to be as brief as possible. So the first one says to create, amend, revoke, or terminate an inter vivos trust other than as permitted under section 55602. This might come into play when a person is trying to qualify for some sort of government benefit and there needs to be a trust established during their life, maybe a special needs trust or something along those lines. But it usually comes into play under those set of circumstances. I don't know if you've ever seen it pop up in any other set of circumstances.
Not that I can think of.
Okay. And then gifting. I usually have to explain to clients that the agent can make gifts on your behalf to different people. Maybe you want them to make gifts every year to your grandchildren during the holidays or for birthdays. And then I have some clients who are like, I don't want to give them the authority to make any gifts at all. Or I want to give them the ability to make gifts, but they need to ask my permission or like consult me about it. The create or change rights of survivorship. So if the principal has a survivorship benefit, like maybe jointly owned property or bank accounts that they have a survivorship right to, this gives the agent the ability to modify it or create it. And for, again, I've seen this come up in when someone's trying to qualify for government benefits, where this might come into play, where you might want to change the person's ability to receive said property. And then there's create or change a beneficiary designation. You'll see that with annuities or insurance policies. The agent might feel like, I don't want anybody being able to alter the beneficiary designation. So you would just remove that. Delegating authority granted under the power of attorney. This is something that's always really, really important to discuss, because this is the agent being able to delegate what they're able to do on the principal's behalf. And so the principal might not feel comfortable with that. So if this is something that, this is just something that's really, really important to explain to the client, because you want the authority and the power delegated to someone who the client trusts, who the principal trusts. And then number 6, waiving the principal's right to a beneficiary of a joint and survivor annuity, including a survivor benefit under a retirement plan. This might include, so under this power, the agent can waive any of the principal's rights as a beneficiary in a joint or survivor annuity. The annuities are a form of retirement planning where the principal and a spouse, for example, might receive some sort of lifetime payment. And again, for individuals who might be trying to qualify for government assistance, this might be something that the agent may need to do. So it's important to explain that, because they may need the authority to be able to do those things. Exercising fiduciary powers that the principal has the authority to delegate. So this allows the agent to potentially, for example, if the principal is acting as power of attorney for somebody else, and you can always correct me if I'm wrong, this is just an example. If the principal is acting as power of attorney for someone else, the agent might have the ability to exercise those fiduciary powers as well, if the principal for some reason can't. And then disclaiming property, including a power of appointment. This property could include inheritance under a will or trust, or life insurance proceeds, or a retirement account, or an employee benefits plan, maybe a pension, jointly held property, maybe pay on death accounts. This gives the agent the authority to disclaim the principal's ability to receive those things. Again, I see these come up in situations where a person is trying to qualify for government benefits, and so their agent needs to be able to have the authority to do those things.
And can you play around with the language? I think Vijaya, you're gonna interrupt us, I think, if there's any questions.
Because that was a mouthful.
Okay. My question is the hot powers language, are attorneys free when they're drafting to just really like tweak or expand upon the language in there to suit what the client's wishes are?
That's a good question. The only one, to be honest, that I've played around with is the gifting.
Specific.
Yeah.
We've seen volunteers alter it to add more details or make it more restrictive.
Okay.
The statute is very vague, so the more detail you can put in there that is reasonable, of course, is actually helpful.
Okay. Thank you. Anybody have questions about the hot powers? Drafting and execution. Client should pick an agent and an alternate that they trust completely. This is someone who's gonna be able to do things like sell your house or manage your financial affairs. So it has to be somebody that you trust. The financial power of attorney includes a statutory notice that has to be signed by the principal. So that's the first page of the document. This is required by law. And then there are acknowledgements that need to be signed by the agents. This is the principal has to sign actually before a notary in order for this to be executed according to the statute. And then the acknowledgements Vijay, you could correct me if I'm wrong, the document becomes effective once the principal executes it and fully signs it, but the agent can begin to act once they acknowledge the acknowledgement that's attached, correct?
That's correct. So the financial power of attorney actually takes effect almost immediately once the principal signs in front of the notary and the agent signs their acknowledgement. It's got all the power, which is another reason you want an agent that you absolutely trust, because they can be doing things with your finances at the same time you are. It doesn't wait for any particular event to happen or for you to say, okay, well, now I want you to use it. It's got the power right away.
And can the principal decide to hold off on having their agent execute the acknowledgement? I know I've had some
Yes.
clients actually decide that that's what they want to
Yeah.
do.
So if you trust your agent, the person you're choosing as your agent completely, then you should be able to have a conversation with them and say, listen, this is where the financial power of attorney is. Should something happen, or I tell you to then sign this acknowledgement page, or you can also have them sign the acknowledgement page, but you hold on to the original and any copies until you give that person permission to go get it. But the agent should definitely know where it is. Otherwise, it's going to serve no purpose if they can't find it when it's necessary.
Thank you.
Yeah, and that actually covers most of the civic side, I think, as well. I can chime in on this last piece too. Vijay had attended a training recently, actually, where they were talking about giving guidance to agents when you're wrapping up your representation, and about making sure they're aware of their duties and responsibilities as the agent. And, you know, it was suggested to like try to have some direct communication with the agent about that, which, you know, when Vijay and I talked about it, we were a little squeamish about, you know, you may or may not feel that it's appropriate to be having direct conversations with the agent that your client has elected. I think it really depends. And sometimes it's the daughter who's bringing the client in and is actually living with her and, you know, helping her with, you know, daily activities of life. And other times it might be a child, you know, that they may not be quite as close to, that you haven't interacted with. And so we're not necessarily asking that you all have, you know, a verbal conversation with all of the agents. And again, your duty is to our client, right? Not to the agent. You're not the agent's attorney. But because of that, Vijay and I thought that it would probably be a good kind of, you know, moderate interim step to have a template letter that you could provide either directly to the agent or to the client who provides it to the agent to kind of explain some of this. And explain what their responsibilities are, you know, as the agent under this power of attorney.
I actually think that's a good suggestion. I think when I meet with clients, one of the things that I always say, and that's why I love the way you guys break up your clinics, is you want to like have a conversation with folks so that they understand the responsibility that being a fiduciary is. Mm-hmm. There's another interested party or somebody, say you have your daughter as your agent and another daughter is concerned about how you're handling things, they can petition the orphans court and require you to, if they have standing, to provide a formal accounting of how you've been managing your mother, for example, or the principal's affairs. So it's like you have to be very, 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 very diligent about how you are keeping records and like how you are managing things, because at any point somebody could come in and say, an interested party, I'm concerned, or reach out to PCA and say, I'm concerned about these things. So I always suggest that clients have really robust conversations with the people that they're want to name as their agent, so that they know the level of responsibility that this comes with.
Okay, before we move on, does anyone have any questions on financial powers of attorney they want to throw out? Sure.
Can you just explain one more time the acknowledgement and the document itself? So the document itself, if it's signed in front of the notary, it's effective. Mm-hmm. The acknowledgement doesn't have to be signed in front of the notary. Mm-hmm. but
it can be signed at a later date. So that my understanding is the agent can't operate under this document until they've actually signed the acknowledgement.
okay, thank you.
Not a problem. Any other questions? Okay.
Okay, all right, thumbs up from Jai, so I think we can keep going.
Okay, the healthcare power of attorney. This allows the agent to make healthcare decisions on behalf of the principal. Again, this has to be somebody who you trust. They're going to be making decisions about your treatment options and hiring and firing different medical professionals or home health aides, and they have authority to admit you to a nursing facility. This is another document where you want to think about who you're naming as your agent, whether or not you want co-agents, your successor agent. Again, I've had clients who are like, I want both my daughters to be named as joint agents, but this daughter has the final say, or maybe this person, not either daughter, has the final say over what happens. One of the things noted here, medical professionals are legally required to try to communicate with the patient first, even if the patient has a HPOA. I try to explain to the client, and sometimes when they have family at the clinics as well, that this is a document where the agent is also supposed to be working in concert with you. So if you still have the capacity to make these decisions for yourself, but maybe your daughter is at the doctor's appointment with you and the physician is looking at her like, well, what are you, and mom is fully able to make the decision for herself, she can make the decision for herself. You can go to the next slide. Do you have a question?
And that's an if you're dealing with someone who has dementia, for example, that requirement is not applicable. Or are they still going to try to engage the person who's?
I would like to think that the medical professional would still try to engage the person, because even with dementia, I feel like I'm biased. Even with dementia, I feel like the spectrum in terms of capacity can vary on the day. That just based on my own personal experience with my grandmother, I remember when she wanted they wanted to give her a pacemaker, and she read the document and was like, "Is this gonna help me?" And the doctor said, yeah. She was like, then I want the pacemaker. Like she had all her faculties that day, but then there are some days where she just didn't. I don't mean to go on a rant about that, but
I think that's a great example. And there's like the realm of the spectrum for dementia is, we'll have clients call sometimes and say, well, so-and-so has, my grandmother has early onset dementia. Well, you can still have a lot of capacity to make a lot of decisions. So this is kind of nice because it allows that medical professional to defer to the actual patient when they are of a sound mind. But if they're having good days and bad days and it's a bad day, that they have an agent who's authorized who can step in and be turned to make those decisions.
Thank you. I feel like I already addressed the first bullet. So they have to choose a trusted person. You want to review all the powers with the client. So on page 4 of the document, there are specific powers listed that the client can actually cross out if they don't want you to have the authority to do these things. So, for example, to authorize, withhold, or withdraw medical care and surgical procedures. Sometimes number 2, to authorize, withhold, or withdraw nutrition, food, or hydration. I might have clients who are like, even if I'm not doing well, even if I'm on my last leg, or I'm a vegetable, or anything happens to me in that regard, they still want food and hydration. So that's one that I always see kind of like, every client is different, but one that I always see that stays consistently. But these are powers that you should go through with them and let them make the decision about whether or not they want their agent to be able to do these things. Anybody have any questions about the specific powers listed?
Yeah. Sorry, can anyone hear me?
We can hear you. Go right ahead.
I had a question in this particular document. One was for the powers. If we cross everything out, let's say, does that presume that they basically want all treatment? In other words, they don't want to exclude anything.
It's, 'cause, 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 'cause,
I guess what I'm saying is like, do we have to actively list specific things that they may want on the list, or if we just cross sort of everything out, it says, it's basically saying, hey, I don't want to forego any of these, any type of treatment, basically. Basically want it all.
That's a good question. I actually don't have the answer to, so I'm not even going to try um I'm not even going to try to steer you in the wrong direction. I don't want to. I've never had clients want to cross them all out. There's usually one or two, or they all just stay.
I did an estates workshop. I forget who it was with. It wasn't with Philly VIP, but they sort of had their list the opposite, where you selected kind of what you wanted. I think it was. It was a little bit different, but um, I just want to make sure that if they ask for that particular option, like what to do. Um,
We can get you the answer to that. We'll get the
okay.
answer, relate that to everyone, because that could be something that any of you could encounter with your client. It's a great
Yeah.
question.
There was one other thing. I don't know if you guys are going to touch on it or not, but in that, I think it was one of the templates that I was looking at from your website. Towards the bottom, I believe there was a couple clauses about general guidance for the healthcare agent in terms of like some irreversible medical condition or severe brain damage. Sort of right at the bottom of the document. I'm wondering like how that contrasts with the living will portion of the document, because it seems like it's getting into these like end stage treatments, whether there's sort of like a conflict with that or not.
I think are you on page 8?
Let me see here.
It should be page 6.
Let's see, page. Yeah, page 6 I was looking at. Those
And
two.
you're talking general guidance for the healthcare agent?
Yeah, it says something about like if I have end stage medical treatment or irreversible
Condition.
medical condition. That seems like it's kind of getting into like the living will almost type of
This is living will.
scenario.
Right. Sorry, what were you saying?
It references the living will. It says, do this as I indicate below, which is the part 3.
It does. So it serves as guidance for the healthcare power of attorney agent.
Okay.
So just as a reminder, the healthcare power of attorney document and the living will are actually separate documents, but since they're connected, they can be combined into one, which is how our template is. So those two paragraphs are meant for the healthcare power of attorney agent. If I suffer severe brain damage or brain disease, I I want this to be treated as if it's the same thing as an end stage medical condition turned to my living will or otherwise. Does that clarify that?
Okay, so if they agree, if they check, they agree, basically, they're just saying that it's going to go to the living will, whatever's in
Yes.
the living will. Okay.
Yes.
They don't have to
And then
put,
with
they don't have
go
to
ahead.
fill anything out really in the general guidance section then.
Not necessarily. I've seen a lot of clients in the general guidance just put the usual, if it's time to let me go, or if they have any specifics they want their agent to know, if they're in some kind of end stage medical condition that's outside of what the living will already covers, or if they have anything specific, or just a message for their agent, usually it's a loved one. That's where you can put that.
Yeah, I'll add, I've had clients who have put Bible verses, or they've said, I want to be kept clean, make sure that I'm washed every day and that my clothes are changed and things to that effect.
That's a great, thank you, Rep, for those questions, and we'll still get back on the first one.
Okay, sorry.
No, you're good.
Execution, you want to sign and date in front of 2 witnesses and a notary if possible, but this is a document that doesn't require notarization. Yeah, the client must have an expired government issued ID to present for the notary. I think we can shift to the living will piece unless anybody has. Okay. I would say that this document actually, for me, I don't know what other volunteers have experienced, but it's always the longest document that I have to go through with the client. Some clients will bring family members, and family members will start to chime in on this part. And I always have to like let the family member know that unfortunately, you know, they try to dictate certain decisions because it's hard to think about these things. And I have to let the family member know, like, it's the client's decision, not yours, unfortunately. But it just takes people a minute to grasp like what kinds of things I would want to have happen if I was at end of life. So this is a document where I would say try to have as much patience as possible with the client. It's because it's basically like, I like to call it like their last statement, you know, because it comes into play if you're unconscious, like a permanently unconscious, or at end of life. It's like your last statement to your family, to physicians. I'm belaboring the point, but sorry. You can go to the next slide. So end stage medical condition is an incurable or irreversible medical condition that will, in the opinion of the physician, result in death despite continuing medical treatment. The physician certification as end stage is not intended to prevent treatment if the patient would benefit from the treatment, or if the treatment will not merely prolong the process of dying, and only one physician is needed to certify the patient at this stage. You want to discuss the client's preferences. You want to review the document carefully with the client, especially, I know number 3 usually takes the longest for me in my experience. You all might have different experiences. Had to remind the client that this is like only comes into play if you are permanently unconscious or at end of life. Because sometimes they'll read it and think, well, I am currently on dialysis. I would need my dialysis. I don't want to scratch that out. And it's just like this, only under these set of circumstances. And then you have clients who just off the bat know, like, if it's my time, it's my time. If there's nothing that can be done, I don't want to be just laying in a bed like a vegetable. So you want to review the document carefully. Same execution format, signing before 2 witnesses. And this is not a document that needs to be notarized, but is recommended that it be notarized. Does anybody have any questions about the living will? I do think it's important to emphasize to the client that they should also discuss these things with their agent and their family members, that there are no surprises when these things come up. There is a section in here where on page 6, healthcare agents' use of instructions. I try to emphasize this part with the client as well, because sometimes there are clients who, when we're going through the document, I can tell they don't necessarily want to have it could be their child like dictating these things, and they only want them to just view this as like, as it lists as like guidance, but that they have the final say, or they want them to follow it to the T. I had a client who had a daughter who was in the healthcare profession. And so she felt like, I want my daughter to have the final say, but she can like use this as guidance. So I think this is important to emphasize to the client, and like, that there is some wiggle room here. At least that's how I view this provision. Does anybody have any questions?
This is a document that most of you will be doing a lot of counseling on with clients, because it's one of those difficult things for them to think about, in addition to they're seeing, oh, well, their first reaction is generally, well, if there's hope for me, I want everything, right? But you've got to remind them this is not what that's for. If there is hope, this does not apply. It's only if there's essentially no hope left, unfortunately, that these are the circumstances that that you don't, maybe they don't want the feeding tube or something to that effect.
Okay, all right, I'm gonna move us on to wills. I just want to make sure we have enough time to cover a little bit on wills as well before we kind of wrap up with logistics. No, you're good. It was a perfect, I think wills are actually more straightforward. I think the powers of attorney are actually a lot trickier and take a lot. You need to go very carefully through those documents with your client to make sure they really are thinking through each set of circumstances, especially the difference between the healthcare power of attorney and the living will items, I think is really important. So there's a lot about the will itself that is a lot more straightforward. So, you know, our focus is really on simple wills with more straightforward dispositions. If you have a client who starts talking to you about trusts or other more complex things they want to do, you can pause and call VIP to talk about it. Usually those clients have already brought those up to us at VIP and we've already had some pretty clear conversations with them. So hopefully by the time they get to you, they really are set that they really want a simple will, but for whatever reason that doesn't happen, please just call us. So, you know, there's some basics of wills that you should know. I mean, you just need to be over the age of 18. It should be in writing. It has to be in writing. Generally there need to be 2 witnesses to the will. The exception to that is if it's a holographic will, which is a completely handwritten will. You don't have to have witnesses for that to be valid. Not really an issue here because we're not training you all to produce handwritten wills, right? We are giving you a template that you will be able to mock up. The most important piece really for the wills you all are going to be preparing, one of the most important pieces is the self-proving affidavit at the end, which is the last page of the will, which I'll touch on a little bit at the end. But that's a really important piece because if that is executed properly, then witnesses to the will do not have to appear when the will is probated one day when the testator has passed away. Instead, having that self-proving affidavit alone is enough for the will to be admitted for probate. So that's a really important piece, and that we want to make sure clients and their witnesses are executing the document correctly to make sure it's considered self-proving. But before we get too much into execution, I'm talking a little bit more about kind of the contents of simple wills. So a really important piece is who you're naming as executor. And this does not need to be anyone who is getting anything under the will. It does not need to be a beneficiary. It can be a beneficiary. Sometimes folks will have one sole beneficiary who is also the executor. That may make a lot of sense. But it doesn't necessarily need to be. It really depends on the situation and what the client wants. Just like when we talked about agents, it really needs to be someone who the client trusts. And if they have multiple beneficiaries that they're leaving things to, it should probably be someone who is going to be able, who is trustworthy and is going to be able to navigate any of those family dynamics that come up and is going to be able to carry out the wishes contained within the will. It's important to also name an alternate because there's a very reasonable chance that by the time our client passes away, the person they named as executor may not be alive or willing or able to serve. And so having that alternate put in is going to make it a lot easier on the family rather than having to go through a whole process and figure out who's now going to be administrator of the estate. We instead just have an alternate who's already named in the document ready to go. Another important point, just like we talked about with agents under power of attorney, having co-executors is tricky and it's not recommended. And if your client says, I want to have both of my daughters serve as executor of my estate, that's a really good time for you to start counseling them about, You know, do you understand that they have to do everything together? They have to sign every document together. They need to act together. It's not just one of them shows up and that's good enough. They both have to show up and be involved. That is often not a great idea. So counseling your client and making sure they really understand that it's not an either or, it's both acting together before they name co-executors in that will. Another important component is obviously who the beneficiaries are going to be under the will. So you obviously want to go through our estate planning questionnaire that we have in the training manual. Really is great for walking through, understanding who is in the client's family, and then understanding who the client thinks they want as beneficiaries. And those two may or may not match up. They often overlap, but they don't have to. And talking to the client about things like, are any of the beneficiaries currently a minor? Are they living with a disability? Those could raise additional wrinkles. That it may be for minors, we may just need to put in some language that we have here at VIP about who would be the guardian of the minor's estate. For beneficiaries who may be living with a disability, we may want to pause and think about whether there could be any implication for any public benefits they get and if we need to do anything different. Also, it's important if the client is talking about leaving individual pieces of property to multiple beneficiaries, right? I own a house and I want to leave it to all 5 of my children. This is the moment for you to pause and say, is that going to be the best thing for your family? And the answer may be yes. Some clients say, like, I want this home to be a landing spot for any of my children or grandchildren who fall on hard times and don't have a place to go. I want this home to be there for them, right? But for other clients, you start talking to them and needling a little bit, and they start explaining, well, my one son's in California and has a house of his own, and I'm not really worried about him. And my other son's down the street, but he's got his own house, not worried about him, but it's my daughter who lives with me and takes care of me, and I want to make sure she has this house. Maybe the client thinks like I need to leave it to all 3 of them, but it turns out in conversation with you, there's really one person the client's really concerned about. That's an important conversation to have with the client. And maybe it doesn't make sense for all 3 kids to be the beneficiary of this house. Maybe it makes sense for there to be a life estate that goes to the daughter so she can live there during her lifetime. And then when it's sold, it gets split between all 3 of their family trees. There's different ways to do it. We can help you come up with the language if that comes up. But again, I just encourage you to pause and gently prod the client a little bit on whether having a lot of beneficiaries for a piece of property is really what's going to be in the best interest of the family, and particularly the family that they really want to make sure they're taking care of. You want to make sure you're naming contingency beneficiaries if at all possible. If the client has folks that they would like to take certain pieces of property, if the person they name as the primary beneficiary is no longer around, so that, the will that you drafted actually has some effect and it doesn't just fall to the residuary clause, which we're going to talk about in a second. The other thing to know is spouses. If your client is still legally married at the time you're making their will and still legally married at the time of their death, but they don't actually want their spouse to get anything, it's a little tricky. It's not really that simple. I feel like this takes me back to trust and estates back in law school a little bit. But you all, who remembers elective share from law school, it's a thing. And it's a thing in Pennsylvania where you can't really just disinherit your spouse. And if you attempt to do that, you can certainly put it in your will. I don't want my spouse to have anything, or you just leave them out and you give everything to your kids or whoever it is. But then upon your death, when that will is probated, your spouse is supposed to be given notice by the executor that your will is being probated and they're not in it. And they have a certain amount of time, which I think is 9 months. It could be 3. It's 3 or 9 months, I have to double check, where they can come forward and assert their elective share against the disposition in your will and still get 1/3 of your estate. So it's important to let your client know that, and that the only sure way to make sure that their spouse gets nothing is to divorce them before you die. That's it. Otherwise, you have to hope that they don't exercise their elective share right.
If you run into that issue, just reach out to us. We may have some solutions for you.
Thanks, Vijaya. So obviously you want to understand the client's property that they want to leave in the will. We will send you the deed to the property that they own, because pretty much any client we're asking you to prepare a will for owns a piece of real property. So we will send that to you, but making sure that you understand what, everything that they own that they want to make sure is disposed of in this will is one of those important first steps. Important to note with real property, if they own their property jointly with another person, the will may not control who that property goes to. And just another point of education for the client, right? If they own the property is joint right of survivorship with their sibling, their sister, for instance, it depends on who dies first as to who owns that house, right? So the client can say, well, I want this property I own with my sister to go to my kids when I die. But if the client dies before her sister, the will doesn't mean anything, right? The sister becomes the sole owner of the property by operation of law upon the client's death, and the client's kids get nothing. Now, the reverse is also true. If the sister dies first, everything goes to the client. So now having that disposition for the property in the client's will is very important. It's always okay to have it in the will. It just is important for the client to understand it will not go into effect if you die first in that situation. It will go into effect if your sister dies first. If we're not asking you all to be property experts, so if you're confused at all about that, when you get your case and you get the deed for your client, we're happy. We know that stuff very well here at VIP. We're happy to make sure you're very clear on how your client currently holds title and what that means in contrast with what's in their will. Also, so personal property, that can obviously be disposed of in a will. There is something called a tangible personal property memorandum that can be used, and we can send you a template of that if a client is interested. The great thing with that memorandum is the client can get really specific about things that might, at some point, the level of detail in the will might be too specific, but more importantly, it gives the client the flexibility to change who that personal property goes to later on without touching the will. Because if a will gets marked up and crossed out, it becomes invalid very quickly and we have a problem. But if you have the separate memorandum, then the client can alter that throughout their lifetime as they wish, and it doesn't affect the validity of the will. So that could be a way if a client is going through and listing really specific pieces of jewelry and specific pieces of furniture, that are heirloom property that they want to make sure go to certain people, but maybe they're kind of changing their mind or they're uncertain. That might be a good alternative, so that that level of detail doesn't end up in the will and it doesn't have to be changed every time the client wants to change their mind. Residuary clause, this is really, really important. This is right. Anything that the client, the testator owns at their death that is not specifically devised or bequeathed somewhere in the will gets distributed according to the residuary clause. This is the residue and remainder of my estate goes to whoever. The residuary beneficiary can be one person, it can be multiple people. But something that is really important to know here is that if the person you named as executor in your will cannot serve, and then the person you name as alternate executor cannot serve, under Pennsylvania statute, the next person who has a right to serve is the residuary beneficiary. So this person has a lot of power in that respect, right? Now, granted, they still have to abide by everything else in your will. They can't just willy-nilly start doing what they want. But they would be the next person to step into the shoes of executor. So it's important to let the client know that it's not just who gets the rest of my stuff. It's also, this is kind of like your third executor in a way, right? Your third choice executor. And it's important that they understand that when they're figuring out who they want to be a residuary beneficiary. But it's really important to have this clause in there, because if you don't, then it goes to whoever your intestate heirs are, your heirs if you have no will. So it is important in the will to make sure you've got that residuary clause in there. We're running a little low on time, so I'm not going to talk much about non-probate assets, but obviously there are things the client may own that may not go through the probate process and may not be governed by the will. So life insurance, I think most of us know that, right? You can list beneficiaries for your life insurance. Same with your pension. If you don't list a beneficiary, it's going to go to your estate, and all of a sudden now it is part of your probate estate, which means it is subject to inheritance tax, and it's going to go to whoever your heirs are according to your will. So it's important that clients just be reminded, like, hey, if you've got those separate policies or benefits, you're going to need to separately update those and make sure they have the beneficiaries listed that you want to have. But those generally pass outside of the probate estate. Will execution, after you've prepared the will, it's obviously really important to go through it just like you would do with the powers of attorney, carefully with the client, and make sure that it really does look like what you and the client have been discussing and has their wishes properly laid out. When it comes time for actually executing that document, again, 2 witnesses in front of a notary, that's all best and safest. And that's what, we are here at VIP to help make that easy for you and your client, to make sure that it's notarized and witnessed. Again, this mention of self-proving affidavit, which is should be the very last page in the will template, is the self-proving affidavit. I mean, to be frank, I think it's like the silliest document in the world. It's just like, yes, what we just said on the prior page where we witnessed is really what happened, and it's notarized. But that one page makes life, oh my goodness, so much easier. We do a lot of probate cases here at VIP, and I can tell you, if all of the wills had self-proving affidavits, life would be easier. So really important to make sure that additional self-proving affidavit is done. The client should keep the original will. You can send a copy to VIP so we have it, but it's important that the client hold on to that original. They keep it in a safe place. We always tell our clients, do not put it in the safety deposit box at the bank, because no one is going to be able to get to it, because the person who needs to get to it is your executor, which is named in your will, which is locked up in the box. So they need to keep it someplace safe. They should make sure their executor knows where it is. Financial power of attorney, the original may need to go to the bank, so the client should make sure they retain that. But generally, the healthcare power of attorney copies, from what I understand, copies are sufficient. So they don't necessarily need a lot of originals of that one, but the original will is important. You can probate a copy of a will. It is harder to probate a copy of a will. So making sure the original is properly handled is important. Okay, we've talked a lot about counseling the client, which I think we've impressed upon you, right? Your job is not just to spit out the documents. That wouldn't really be any fun, and it would be really boring of us to ask you to do that. The interesting part of these cases is being able to have a conversation with the client and try to translate the wishes they're telling you into the legal document. And hopefully we've made that easier for you with our templates, but again, we're only a phone call away if you're not sure how to translate your client's wishes, so to speak. This is a nice little chart. I'm not going to go into in detail, but my takeaway from this chart is just make sure there's 2 witnesses in a notary, because it's safest for all of the documents, right? Some of them are valid without that, but it's the best thing to do. So when it comes time for notarizing your client's documents, doing that final document execution, it's easiest if we can get your clients in here at VIP so we can make sure it's done properly. So getting to the logistics, I apologize, we're at 1 o'clock, so if folks can give me 5 minutes, and then I promise I will let you go. It might not even be 5 minutes. But many of you have already been matched with a client who is ready to have their estate planning documents prepared. I know some of you are going to be matched with a client shortly. If you already have a client, we have prepared them to expect a phone call from you later today. So that you can, get started right away and put some of this, actually keep this fresh in your brain. If you're like me, you kind of forget things 2 days later. So we thought that would be helpful for all of you. And then after that, one of the first things we suggest you do is prepare a representation agreement for your client to sign, so that it's clear to them what the scope of your service is, which is helping them with their will or their power of attorney. And if something else comes up, you can let us know at VIP. We will work with them on any other legal issues, but you are here to help them with their estate planning documents. We have access to DocAssemble that we can help you get that out electronically, that representation agreement out electronically to your client to sign if that's easier. That's all in the referral email that we've sent you, so that information is there, but just let us know. We're happy to help coordinate that. And then, you know, as your client is deciding what they want in these documents, it's drafting the documents. You may want to send them to the client for review a week or two before we try to come back and meet on November 14th, to let your client sit with it, look it over, talk with them again one more time, make any more changes before you come in here. We will have it's challenging, I will say, on November 14th to do a lot of document editing when you all are in here, because we're going to have a lot of folks in here. So it's a little bit easier. We'll go smoother and we will get you and your client out of here more quickly if you're able to try to do some of those edits and do a first draft before you come in and make any of those changes. But certainly we don't want any client signing a document they're not happy with. So if it comes up at the last minute, let's make the changes. We're going to get it done. So the goal is that we try to make this a really defined scope of representation for you all, that we've got this date set on November 14th, where you and your client are invited back to our office. We have lots of VIP staff who are used to serving as witnesses, and we have VIP staff who are used to serving as notaries. So we've got the people you need. It's just you, the documents, and your client who we need from your side. So the goal is between 11 a.m. and 4 p.m. We'll send out like a sign-up sheet electronically to try to schedule folks' times. If that time doesn't work for you or your client, that's fine. We'll work with you to otherwise figure out how we can help your client get those documents executed properly. Vijaya, is there anything else, especially logistically, you would like to chime in on?
Feel free to send us drafts. We're happy to review them for you ahead of time. If you have any questions, reach out. In regards to the will, our template has the most common clauses in there, but every now and then something else pops up. Reach out to us. We probably have language already saved and ready for you. Just reach out and let us know. I think that's about it.
I think so. Okay, all right, well, we will hang on here for a few minutes if folks have questions, but we'll officially conclude so folks can go. I apologize, we went 4 minutes over, so thank you for your patience. I tend to go like 15 minutes over with the intern, so we're really letting you all out pretty early that way. But thank you all for coming to this training, but thank you even more importantly for volunteering to help one of our clients with their estate planning documents. We appreciate it, and it's vital, and it gives so many of our clients this peace of mind that things are hopefully going to go smoothly and their wishes are going to be written down. And for a lot of clients, they've been thinking about this for a while and they finally have gotten in and decided this is the time they're going to do it. So it means quite a bit to your clients to have these documents at the end of the day. So we appreciate you doing it, stepping up to help one of our clients. And like Vijay said, we are all a phone call or email away. So whether it's me or Vijaya, if you want to follow up with Sierra on something she talked about, we can put you in touch with Sierra or any of the VIP staff members you're in touch with who are sending your client's case file to you. There's no wrong person to talk to at VIP. So just reach out to any of us and we'll get whatever questions answered or strategize with you or whatever it might be. Okay, thank you all. Any other questions from folks online? No, Linda, did you have a question?
No.
Okay.
Mm-hmm.
Okay. All right. Okay. Well, thank you, everyone. We appreciate it.